as you can see, and as Ilgar said, my name is Annabel Bazante. I have a small boutique law firm on the border of Franklin Square and Elmont, and we specialize in elder law and trusts and estates matters. That includes litigation, including guardianships and will contests. But for tonight, what we're talking about is the component of elder law called Medicaid eligibility planning. And so what I'm going to be talking about tonight, with a focus on preserving your home, is how to ensure Medicaid eligibility while preserving your assets. So at times I'm going to speak to you as though you're the person who's looking to be eligible for Medicaid, but it could be you, it could be a loved one, could be a good friend. It's important to have this information because so many of us do wind up, even if we don't lose capacity between where we are now and the end of our lives here on earth, very often we really need assistance. And most of us in this, certainly in this part of central Nassau County, many of us really can't afford the can't afford to pay for a home care attendant round the clock, or to keep ourselves or loved ones in a nursing home or skilled nursing facility, as they call them, for any significant period of time. The costs are unbelievable. As you probably know, you can easily pay $20, $25, $30, $35 an hour for a skilled home care attendant to come to the house and help care for you or a loved one. Nursing home care can easily run $12, $13, $14, $15,000 a month, depending on where you go. So these are big numbers. They really add up. And so what a lot of us try to do for ourselves and for our family is to prepare ourselves so that if there does come a time when we need assistance paying for this type of care, unavoidable need for care, we might be eligible for social services to help pick up the tab. So I'm going to give a little bit of an introduction, and then as promised, we're really going to focus tonight on how to preserve your home. Basically the way I describe the eligibility test for Medicaid, for elder law type of Medicaid, is a three-pronged tool. First of all, the individual applicant has to be disabled, seriously disabled, such that the person needs help with several activities of daily living. That could include getting dressed, bathing, toileting, preparing meals, shopping, all different types of self-care. Another leg of the stool is the amount of resources a person has. Currently, and I'll repeat these numbers again, if an individual owns assets worth more than $16,800, they are considered over-resourced and therefore ineligible for social services to help pick up the cost of home care or nursing home care. There are exceptions, and that's what we're going to be talking about. The third leg of this stool is income. If we're talking about home care, an attendant coming to the house, your income for an individual must be $934 a month or less in order for your income to not be considered excess income. If you do have income in excess of $934 a month and you are disabled and your resources are below $16,800, again, for a single individual, there are ways of shielding. Shielding's not the best word, but sort of manipulating your income to help bring you down to the allowable level. How we do that, I'm not going to go into the details tonight unless we have time later and there's interest. You would use something called a pooled income trust. This is not the type of trust document that an attorney would draft for you, but rather it's an arrangement made with certain types of charitable organizations whereby you would have your excess income every month transferred into a special account in your name, and then you could use that excess income from that pooled income trust account and use it to pay certain of your expenses. So it sounds sort of crazy. You have to take your income from your account, put it in this new account, but then you can still use it after paying a modest fee to the organization running the pooled income. Then you can qualify income-wise for Medicaid. If you have questions about that, make a note and we'll come back to it later, because I do want to finish the introduction and then start talking about ways to save your home. Medicaid, as you may know, is jointly funded by the federal government and states. An application gets filed by the local Department of Social Services or at the Human Resources Administration for the 5 boroughs of New York City. If your application is approved, Medicaid will pay for the cost of a nursing home for a qualified applicant. To qualify for chronic care nursing home Medicaid, you must be 65 years of age or older, disabled, or blind. And since I started talking about the income test for Medicaid eligibility, I want to just go back and clarify that that pooled income trust technique that can be used to render yourself eligible for home care Medicaid by using this pooled income trust is not available if a nursing home is required. If an individual requires a skilled nursing care, in that case, your income will be paid directly to the nursing home. So if, for example, you or your loved one, you're in a nursing home that costs $13,000 a month, and your monthly income is $3,000, most of your income, less $50 a month, will go directly to the nursing home to help pay for the cost of your care. And if your application for Medicaid assistance is approved, Medicaid will pick up the remaining $10,000 or so of that big nursing home bill. If an individual already has no assets, if a person is living alone, for example, and has a modest Social Security or disability income and does not own their own home, first of all, I don't know how you're making it in Nassau County unless you have generous loved ones around you. But secondly, there's no need for you to go to an elder law attorney like myself to fill out your application, because there's no challenge here. Medicaid was designed for poor people. And if you really don't have much of any assets or income, let the nursing home or let the home care agency complete the application for you free of cost. They do it. However, if you do own assets, including a home or an IRA or any kind of accounts or securities, I strongly recommend that you consult with an elder law attorney to find out if there are ways to preserve your assets while also becoming eligible for Medicaid. The criteria to qualify, and I talked about one of these criteria, the resource criteria. For a single person, they must have resources, meaning assets, things you own, that do not exceed the value of $16,800. For a married couple, that amount goes up to $24,600. If you own a home in which you have an equity interest of less than $955,000, then you can still qualify for Medicaid even if you own your own home, whether it's just you or you and a spouse or you and a sibling. We'll talk about all of that later, but you can still qualify. The reason why you may want to speak to an attorney about how to protect that home is because if you own a home that's worth, let's say, $600,000, that's a typical Nassau County home maybe. If you own a home worth $600,000, your other resources do not exceed $16,800 and your income is below $934 a month, or it exceeds 934, but you've established a pooled income trust to handle your excess income, you can still qualify. Your application will be approved and Medicaid will pay for your nursing home care, your home care. The problem is when you pass away, social services can place a lien on that house for the full value of the care that was given to you while you were still alive. There are ways to avoid that by putting your house perhaps into a trust before you need the home care or the nursing home care. Because if your house is not a part of your probate estate or your even an intestate estate, meaning you died without a will, if it's not in your estate, then Medicaid cannot reach it, cannot put a lien on it. As I said, the income limit for a single person is $934 a month. And regardless of your income, regardless of how much gets paid over to the nursing home, if that's where you wind up, you get to hold on to $50 a month, which will go into a resident fund account, and that can be used for incidentals while you're in the nursing home. You know, getting your hair done or, you know, buying some, whatever's available to purchase wherever you wind up living. Countable assets, what counts? Well, I already told you that owning a house with a value less than $955,000 doesn't render you ineligible for Medicaid. It's considered an exempt resource, so you can still become eligible, but being exempt does not mean, as I said, that Medicaid can't put a lien on your house after you die. Other countable assets include cash, checking accounts, savings accounts, stocks and bonds, investment accounts, the cash value of a life insurance policy. Some people, when they come to speak to me, are surprised to hear about that. But when I ask you, what are your assets? Because I want to see if there's a way we can make you eligible for Medicaid. If you have a whole term life insurance policy that has a cash value, that counts as an asset. If you have a very large policy that has a cash value, very significant, we need to get that out of your name as soon as possible so that when you need Medicaid assistance, we don't have to deal with that asset. If you have a modest life insurance policy with a cash value of, for example, under $10,000, maybe you can hold on to that as long as your other assets, in addition to that life insurance policy, don't exceed, what's the number? $6,800. Because remember, if you have resources other than exempt assets like that home that are worth more than $16,800, you do not qualify for Medicaid. Now, I just want to also offer that there are things that can be done that are called crisis planning. If somebody has done no Medicaid eligibility planning and then finds themselves in sudden need of home care or nursing home care, there is a way that we can preserve through gifts and notes, but I can talk about that later if we have time. There is a way that we can preserve perhaps 50% of the value of your assets, but not all of them. In order to preserve the full value of any assets, we need to do Medicaid eligibility planning in advance. So as I started to list some of the assets that are counted in that limit of $16,800. And it doesn't matter whose name these assets are in, if you're married, or even if you're not married. If you own an account jointly with your child because you put him on the account as a convenience so that he could do some banking for you if you didn't feel up to it, that's going to count as your asset, even though somebody else's name is also on it. As I said before, a homestead, a home, can be a house, it can be a condominium, a cooperative apartment, a mobile home. Any of these residences qualify as an exempt homestead. But as I said, the equity value can be no greater than $955,000. Also, if the applicant, the Medicaid applicant, or the applicant's spouse, or their child who's under 21 years old, or their blind child, or certified disabled child, or dependent relative live in the home is also exempt, regardless of how much that home is worth. Okay, so that's something about home. I have a few more things I want to say about homes. So in order to protect your home, if somebody comes to me because they want to be eligible for Medicaid to pay for an aid or home care, if you transfer your primary residence to your spouse, to a certified blind or disabled child of any age, or to a child under age 21, that transfer is exempt. Now, that can work out really well sometimes. If you're married and you transfer the house to your spouse, then you can be eligible, all other things being equal. If you have, as I said, a blind child or certified disabled, you can transfer to them or put it in a trust for their benefit. But a lot of people have more than one child. If you have 3 kids and one of them is certified disabled and the other 2 aren't, you may not wish to transfer the house only to the certified disabled child. You might want each one of your 3 children to benefit from that. So that would require, in order to enable you to do that, you would need to do planning somewhat in advance, perhaps through a Medicaid trust. If a sibling of yours has an equity interest in the house and has been residing in the home for at least 1 year prior to your admission into a nursing home, you can transfer the house to that sibling as well. That's an exempt transfer and will not trigger a penalty period. How many people really want to give their house to their sibling that they co-own the home with? If you do, then you can, and it's fine. But if you have children, you may prefer to transfer your assets to your children. And again, that would require advanced planning. Here's another option that people have that is more frequently taken advantage of than the transfer to a sibling or to a disabled child. If you have what's called a caretaker child who has resided in your home with you for at least 2 years immediately prior to you going into a nursing home, and if that person has provided some kind of care to you, you can transfer the house to that caretaker child. That's an exempt transfer, and all things being equal, you can then qualify for Medicaid, and on your ultimate death, there's no lien on that house because it's not in your estate. It will be then in the name of that caretaker child. If your house earns income, for example, say you have a 2-family house and you're renting one of the units to somebody and rent comes in, even though your ownership of that house could be exempt and not stand in the way of your Medicaid eligibility, any rent generated from that house does count as your income and will increase the amount of income attributable to you and possibly have to be paid out to a nursing home. So some people come to me and they say, now the worst scenario is when they say they've already transferred their house to their child or to their children, because most of the time that is not the best thing to do. It comes from a loving heart. People think, well, I'm getting older, I may as well transfer the house to my child or to my children, let me do it. Well, one advantage is, especially if you've transferred the house to your child or to your children, a number of years ago, outside of the look back period, and I can talk about that after I go through some of these home specific tips I'm giving you. But there are some also disadvantages. Sometimes a person will call me and say, and it happens more often than not. So there's people just don't understand because there's a lack of clarity out there. Sometimes a person will transfer a house to one of their children because they want to get the house out of their name so that they'll qualify for Medicaid. Sometimes they transfer the house to a family member because they have creditors that they don't want to reach that house. Sometimes they put their house, what they consider to be their house, in the name of a family member who's got better credit so that they can get a mortgage, right? There are all reasons. I'm sure we all know people who have done this. The problem is, if you put somebody else's name on your deed instead of your own, you don't own that house. You may still call it your house. You may still live in that house, but you don't own it. And unless there's a life estate in that deed allowing you to live in that house for the rest of your life, then whoever's name is on that deed can disallow your living in that house at any time for any reason. They don't have to let you live in their home. So there are dangers in doing that. Other disadvantages are there could be gift tax issues. So some of us are aware of the fact that the current amount of a gift that you can give to anyone for any reason every year is now $16,000. If you have 3 children and 16 grandchildren, you can give every one of your children and every one of your grandchildren $16,000 every year and not have to fill out a gift tax return, and certainly not pay any gift tax. If you have that kind of money, you may want to do that for other reasons other than Medicaid eligibility. If you give a home to somebody, that will trigger the need to file a gift tax return. Depending on the value of the home and the other gifts that you've made during the tax year, you might possibly be subject to gift tax. The gift tax is generally something that only pretty wealthy people have to concern themselves with. If you don't have an estate in New York that's worth over $6 million, for example, you don't have to worry currently about gift tax, but it's still a concern for some of us, for some people. More important for more people are capital gains issues. If you bought your house a long time ago for $8,000, right? And it's currently, especially in this end of the pandemic housing boom that we're experiencing, if you give that house to somebody now while you're still alive, they inherit your $8,000 tax basis. So if they ever decide to sell that house, they will be subject to possible capital gains tax. Because if the house you bought for $8,000 way back when sells now for $600,000, there's a capital gain of what's 600,000 minus 8? It's 592,000. Is that it? $592,000 gain, and then there will be a tax computed on that. So that's one reason why it's often better to delay the transfer of a home to one of your kids, or usually to a child, but to any loved one, until after you pass, because we still have what's called a stepped up basis, which means if I put my house now into a trust for the ultimate benefit of my children, so that when I die, my children will inherit that house. It can be sold and they get equal shares, or they can co-own the house, whatever the trust provides. But if they don't inherit the house until I die, they will get what's called a stepped up tax basis, which will equal the fair market value of that house as of my date of death. So if I bought the house for $8,000 and I die with the house worth approximately $600,000, that's their tax basis in the house, is $600,000. So if it gets sold that year, there's no capital gain whatsoever. If it gets sold a few years later, there's an insignificant possible tax on the capital gain. So that's another reason why it's not necessarily a good idea to simply deed a house to somebody now. The other thing is, there's a loss of control. for me, if I were to put a house, if I wanted to make myself eligible for future Medicaid, hopefully, knock on wood, that's not going to happen for a long time, if ever, right? None of us really want to be reliant upon a home care attendant or upon a, skilled nursing care, but it happens to a lot of us, so we need to plan. If I were to transfer my home to my children now, while I'm still able-bodied, I still have my wits about me, I lose complete control over my house now too. Why would I want to do that? So, as I said, these are individual decisions to be made. For some people, deeding the house to their child or to their children is a good idea, or to even another family member. But for many people, there are considerations that I want to make sure you think about before you do such a thing, because it can be irreversible. I had one scenario a few years ago where a client came to me, or actually it was a family that came. The client, of course, was the mother of the family, and she had several children, and she had transferred the house to one of her children, thinking, well, she'll share it with the other kids. Now, that doesn't always happen. And what if the child who winds up with her name on that deed, what if she develops credit problems? What if her divorce fails and she winds up, her assets wind up subject to equitable distribution? So her ex-husband winds up with a piece of that. There are things that happen beyond our control, and then her sisters could have gotten no share of that house at all. And the reason why this particular family stands out in my memory and is remarkable is because when I explained to them that the daughter whose name alone was on the deed alone owned the house, she agreed to transfer back to her sisters a certain percentage of that house, so that her mother's actual wishes took effect, which was that all of her children would share equally in this home. And there's no blame to go around, except if I have to blame anyone, and I know you're not making me do it, but I will. It's the fault of the attorney who didn't make sure that this client knew what she was doing. I don't think she realized what that deed said when she signed it. That's my personal belief. I don't remember who the lawyer was. That might not be the case, but I try to make sure that my clients understand, even if they don't understand every little legalese word in the document, I want them to understand what the significant effect of them signing that document will be. I've been talking a lot. I've talked a lot about certain aspects of transferring a home. And now what I can do is I can go back through and give a more general framework for what I would recommend that you do in order to render yourself eligible for Medicaid. But before I do that, I'd like to invite anybody who has a question to put it in the chat or raise your hand somehow, and maybe I can answer any questions before I move on. Hi, Pamela. Can you unmute yourself? Let me see if I can unmute you.
I got it. Can
Okay.
you hear me?
Yes.
Yes. Can you talk a little bit more about this pooled income trust?
Yes, I can. So if an individual, now remember, the pooled income trust is only relevant, is only helpful when it comes to making yourself or your loved one eligible for home care in the house, not nursing home care. It's not relevant to nursing home care at all. If the applicant has income over $934 a month, which many people do, okay, what you can do is create a special sub-account with for example, AHRC and NYSARC are two of the charities that I work with for my clients. There are other organizations as well that do it. I'm not on the board of NYSARC or AHRC. I've just had luck dealing with them. So what you do is you sign an agreement. You pay, I think it's $200 or $250 to set up this account, because that's really what it is. There are generally very helpful people working for these organizations. And every month, you will transfer all of your income that exceeds $934 into the sub-account that you're opening in the pooled income trust. So it's called a pooled income trust because it's comprised of excess income from a lot of different people. It's all pooled in this large trust, but your account, your funds are segregated from the funds of everybody else who has set up a pooled income trust. They are segregated and separate. So every month you are going to contact that pooled income trust, NYSARC or AHRC, and let them know that you need to have the mortgage paid or the gas bill or the, home care attendant in excess of what Medicaid is covering, whatever your expenses are, maybe even a credit card that has been used to pay only for the expenses of the applicant. If the applicant lives in the home with another family member, even a spouse, only expenses that are directly of benefit to the applicant alone can be paid with that excess income in the account. So if you go out to dinner with somebody else or order in or something, and 2 meals are bought, only the meal for the applicant can go on that applicant's credit card and be paid for or reimbursed from funds from that pooled income trust account for the applicant. They're very strict about that. It can only be used for that individual. So the trick is, so it works. So it's a little bit of an effort. It's a small part-time job for somebody because instead of just using your excess income to pay your bills the way you always used to, now it gets diverted into this other account and then used to pay your bills. As I said, they get a small, not small, but they get a fee in the beginning to open the account of approximately $200 or $250. And then every month there is an administrative fee, usually about $25 a month. This is the fee for them helping you become eligible for Medicaid. So who wants to pay that? Well, if you don't want to pay it, then you're not going to be eligible for Medicaid, and you're going to wind up paying a much higher bill for AIDS than you would if you're just paying for this pooled income trust to help you things. So the catch is that you want to make sure that every month, this is the takeaway for pooled income trust. You want to make sure that every month you use, to the extent that you can, every bit of excess income that was transferred into your pooled income trust, every bit. Because if there is income left in that account and the applicant dies, anything in that account as of the applicant's death will revert to that charitable organization. Okay, so that's the catch. Even so, what are we talking about? The excess monthly income, that's all that's going to be lost. And you may very well, especially if this relationship has been going on, for a period of time, you will have saved so much money by having social services pay for your aid that even losing, a couple $1,000s to that charitable organization is not going to balance out. You're still going to be far ahead of the game. When it doesn't work out is, let's just say, you open this pooled income trust, you put money in, and then the applicant dies, right away suddenly. So then, you paid money to try to set up a plan that you hope would work for a significant period of time, and it didn't. But that's sort of the risk you take with that. Did that answer your question, Pamela?
Yes, thank you.
You're very welcome. Does anybody else have a question at this time? Oh, wait.
Yes.
We have questions in the chat. Hold on. Let me see. What about a reversible trust? Do you keep control as owner of house? So by reversible trust, Olga, what do you mean? Do you mean a revocable trust or an irrevocable trust? Is Olga here? I can't see everybody because I'm spotlighted.
I'm sorry, I added that it was a reversible trust.
A reversible trust. So I guess I'm going to assume that you mean a revocable trust, which,
A revocable, yes.
okay. So a revocable trust, and if you could mute yourself, just because there's a little background noise, and I'll answer your question. What about a reversible, or usually the word that we use is revocable trust? Do you keep control as owner of the house? 100%. First of all, I just want to explain that a revocable trust or reversible trust is absolutely of zero value, zero, when it comes to Medicaid eligibility planning. A reversible trust or revocable trust is something that people use perhaps because they want to avoid probate, right? Now, I never used to have anything against probate. It used to be sort of a quick and dirty process. You pay, okay, so there's a filing fee, you pay the lawyer a couple $1,000s, but it balances out. You know, it's not necessarily more expensive or much more inconvenient to go through probate than to set up a trust prior to death. Since the pandemic, that's changed, okay? Probate has become a very drawn out process now and can take a really long time. Hopefully, things will revert to where they were pre-pandemic, and it's not going to take months and months for a will to get through probate. The time when I usually recommend a revocable or reversible trust, I have some lovely clients right now who have children who are their primary beneficiaries. They wanted to put their home into a revocable trust because their children don't all live not only in New York, but in this country. They live in different countries. So they wanted to have a revocable trust, which would make it easier for one of their children as a trustee to distribute the assets after they die to their children without the complication of being involved in a court. That was a very good reason for a revocable trust. Another good reason for a revocable trust is if you have a close family member, somebody who would be required to get notice of your death when your estate is created in court. If you have a close family member who is estranged, maybe they are severely mentally ill or actively abusing drugs, or maybe they're just really nasty and they don't like you or you don't like them, for whatever reason, if you have somebody, very close family member, who you don't want to involve in the creation of your estate, if instead you put your assets into a revocable trust, there will be no need to probate your will or to create an estate through an administration proceeding. You will instead be able to distribute through this revocable trust to whoever your beneficiaries are without involving the court or letting that estranged person know anything about your assets or even your death. Does that answer the question, Olga?
Yes, thank you.
You're very welcome. Okay, so let me see what other question is here. Okay, revocable trust. What happens if I inherit money from my parents' estate? I already qualify for Medicaid. Well, that's a tricky story. So if you have need-based Medicaid and you inherit something, I believe, so that's going to depend on a lot of different things. It depends on how did you qualify for Medicaid? Are you perhaps disabled? Is that it? And so we would have to find out if your receipt of resources would disqualify you. Generally, I think it's based on income, not necessarily a gift or inheritance, but I'm not sure offhand. One thing, however, that often happens, if your parents are still alive, Rich, I'm going to make a strong suggestion that you have your parents speak to an up-to-date elder law attorney and encourage them, instead of leaving money to you outright, to instead have it go through their will to what's called a special needs trust, which will be set up so that you can benefit from those funds bit by bit over the years in such a way that they will not interfere with your disability. I'm sort of assuming you're on disability, but I don't know that for a fact. or even interfere with any other government benefits. There are special trusts that we know how to create, even in somebody's will, that can allow you to benefit from an inheritance without losing your governmental benefits. Revocable, not reversible, Olga. Okay, I agree. How can a home be left for a child after death without probate and estate tax? First of all, estate tax really only affects extremely large estates at this point. Unless your estate is worth more than $6 million, you don't have to worry about estate tax, okay? If you have an estate that's worth more than $6 million, and I certainly have clients who do, then there are some techniques you may want to use to avoid or minimize estate tax. How can a home be left for a child after death without probate? Well, one way you can do that is you can put it in a trust. If you are of the age and it otherwise makes sense for you to create a Medicaid or asset protection trust, then maybe what we would do is put that house in a trust now, right? We could put it in a trust now, and the trust will provide that you can live in that house for the rest of your life if you want to. You never have to. Like if you decide you don't want to, the house can still be sold, or you can move if you want, but you would be able to live in that house for as long as you want until you pass. And then the trust will provide that on your death, the house passes to your child. So you can absolutely do that. If you don't put the house into a trust, it's going to pass through your will if you have one, or through the laws of intestacy of the state of New York, and they'll get it after your death, through probate or an administration proceeding. Does that answer your question, Terry? Okay, I'm hoping it does. If not, if you have a follow-up, let me know. And now Debbie Joyner has her hand up. How can
Yes.
I help you?
Hi, good evening. I do have a question. I was reading about accessible dwelling units, and I wanted to find out if Nassau County does allow them on the property, whether converting a garage or in the sense of quote unquote building a tiny home in my backyard, because I do have the footage. If I do something of that nature, do I have to put the deed to my house in my children's names?
Wow. So first of all, I don't know anything about whether or not Nassau County permits a tiny home on a particular size lot. That's not my expertise, and I'm old enough to be able to say I don't know. But based on your question, would you have to put the house in your? I don't know why that would necessitate you putting the deed in your children's name. I think I understand what you're saying, but maybe I'm not. So is the tiny home for the child? Is that what you mean?
No, it would be for me. It's called an accessory dwelling unit. And I know when you convert a garage into a living space, that's also considered accessory dwelling unit. So if I go the way of putting a tiny home on the property, if it's permissible by Nassau County, or maybe converting the garage, would I have to put my home in, put the names of my children on my deed in the event of my passing, or would I sell my home to my children? And that way just maintain the accessory dwelling unit.
Okay, so, I probably shouldn't even tackle this one because I don't know what I'm talking about with the accessory. I've heard something about it, but I really have not followed up on it.
Okay.
But based on what you're telling me, I don't see a necessity unless the statute or regulation requires it. I don't see why you would have to put anybody else on your deed, unless there's something in that particular regulation of which I'm not aware.
Okay.
If you still own the house and you would own this accessory dwelling, what you may want to do is put the whole thing into some kind of a Medicaid eligibility trust in case you do need home care or nursing home care. That way, the whole thing will be exempt, hopefully, if you don't need to apply for Medicaid for, 5 years is the look back period for nursing home care. 2.5 years is the new look back period for home care. So I'm not even going to ask if I answered your question because I know I really didn't.
Okay, but you did give me some insight into at least where to get it, what to do, or as far as what to think about doing. Because you said put the whole thing, the home and the accessory dwelling unit, into a Medicaid.
A Medicaid asset trust. Now, again, all of that, this answer that I made up is all subject to
Right.
the applicable regulations that have to do with these accessory dwelling units, of which
Okay.
I'm not familiar. But
Okay.
unless there's something particular in there that requires that the whole property be deeded to somebody else, which honestly, I can't imagine that is the case.
Okay.
I wouldn't want to give it up because, again, if you're going to be living in some kind of a dwelling on that land, and you now deed the whole thing to your children, what if they go bad? What if they go crazy? What if they, who knows what? Kids do all
Right.
kinds of things, so I wouldn't want to give up my home. I'd rather put it in a trust with the protection that the trust provides.
Okay.
I had to do something with it.
Okay. All right. Thank you so very much.
You're very welcome. Okay, so Terry's back with another question. Can a home be quitclaimed to a child to avoid probate? Yes, but I mentioned some of the disadvantages of doing this. Number one, if you quitclaim your home to your child, you don't have a home anymore. You don't own it. You live there at the mercy of your child, okay? And sometimes children, get involved with people who don't like older people or are just crazy or see the world differently. I'm not down on children. There are lots of good kids, but the ones I'm afraid of are the ones that sometimes make unexpected and very unwelcome decisions. So I would never want to give my home to anybody while I'm alive. I wouldn't do it. I might possibly put it into a trust in such a way that there are protections, okay, for me, but I would not just simply deed my house to somebody if I still want to live in that house or need the value of it, perhaps. Okay, are there any other, I think I've exhausted the questions in the chat. Are there any questions not in the chat that people have? Okay, so I mentioned briefly, and this is now where, Pamela, did you have your hand up again? Yes? You're muted. Are you talking to us or to somebody else, Pamela?
I'm unmuting right now.
Okay.
What's the difference between life estate and trust?
Okay, that's a good question. So, very good question. So, and it's not that easy to answer, but in general, in this area of the law, the difference is this. Generally speaking, an estate is, when I die, everything that let's just say I own, I'm gonna make myself sound better than I am, right? So I have a $2 million 401k. Let me make notes so I remember what I have. I have a $2 million 401k plan. I have a $10 million brokerage account. I have 2 homes, each worth $3 million, right? That's what I own. So I'm putting my son as the beneficiary of the $2 million 401k. So when I die, by operation of law, all he's going to have to do is contact that financial company and with a certified death certificate and fill out a beneficiary claim form. And that $2 million 401k is going to go to him. Now, it's subject to payout rules. He's going to have to, receive distributions from that over 10 years. He can stretch it now. They've changed the stretch rules, but that will be his, okay? Tax implications aside, it'll be his. My brokerage account, let's just say I have a $10 million brokerage account. I have named my sister as a beneficiary of that brokerage account. When I die, similar to the 401k, she'll bring a certified death certificate to the brokerage house. She'll fill out a beneficiary claim form. She'll get the $10 million brokerage account. My house, I die with no will. I own 2 homes and they're each worth $3 million. So what would happen? My closest relative under New York state law is going to be my son. He's my closest blood relative. He's going to, first of all, be surprised that his mother, who practices law in this area, died without a will. But when he gets over the shock of that, which is, just so you know, is not the case, I do have my documents in place. But he's over the shock. Okay, his mother doesn't have a will. He goes to the probate court in Nassau County and commences with the assistance of another lawyer and at what they call an administration proceeding, because there's no will, okay? And some forms will be filled out, will be submitted to the court, so that I'm backing into an answer to your question. My estate will consist of those 2 homes that are each worth $3 million. So I'll have a $6 million estate, okay? That's my estate. If I died with a will, which I will, okay, instead of going to the court to commence an administration proceeding, my son will instead bring my original will to a lawyer who will help him commence a probate proceeding. And when the court agrees that my will was properly done and is the true and valid will of me, then my 2 houses, $6 million worth of real estate, because everything else, remember, passed by means of beneficiary designations.
Right.
My estate, my probate estate will be $6 million. So if I don't have a will, it's called my intestate estate, meaning I don't have a will estate. Or if I do have a will, it will be my probate estate. That's basically what an estate is, okay?
Right.
It's my assets. What do I have when I die? That's going to pass according to administration or probate. Now, there can be somebody who's going to argue with me. The estate can have other meanings, but in this context, that's what that means. So what's a trust? A trust is basically a contractual agreement with provisions directing that certain assets be handled in a particular way, okay? So if I want to, like we talked earlier, about the revocable trust, okay? I created a document for, I forget who it was. Was that Olga who was asking about the revocable trust? Somebody here tonight was asking a really good question about a reversible or revocable trust. So what I would do is draft a document that says that Olga, as grantor of the trust, the one granting property into it, and Olga also as trustee, meaning the manager or the administrator of the trust, agree to take care of this property, manage it, administer it according to these rules. And then the trust has rules, okay? And some of the important rules are going to be that if the grantor becomes disabled or dies, somebody else is going to take over as trustee or manager or administrator. They all mean the same thing. So the trust has to provide who's going to step in as successor trustee if that first initial trustee can no longer serve due to disability or death. So that's one of the provisions this contract will provide. The contract will also provide, during my lifetime as grantor, can distributions be made from the trust? Can income or principal that comprise assets of the trust be given out while I'm alive? And if it can, to whom and why, for any particular reasons? Does it have to be for health, education, or maintenance of somebody? Can it be for any reason at all? These are some of the rules. Also, the trust will provide that on my death, who's going to get this? Is it going to go to my children, to my grandchildren, to a charity, to my whoever it's going to go to? So a trust is really you can think of it as a contractual agreement that sets up rules for how assets are going to be managed. It's not really an account because you will then take the assets if they're stock or cash, and you can actually create an account that would be in the name of the trust. So a trust can hold anything. It can hold a business interest. It can hold real estate. It can hold a co-op. It can hold stock. It can hold all different kinds of things. Does that answer the question about estate versus trust?
So a trust is really a little bit more complicated than life estate.
Well, okay, so it's really very similar because your will, if you have a will, which I recommend for everybody, your will is also going to have rules, just like a trust would. It's going to provide that, let's just say you name Amy, whoever that may be, as the executor of your will, right? So Amy is going to be the one who's in charge of making sure that your wishes as set forth in your last will and testament get carried out. Your will is also going to provide that if Amy can't serve or doesn't want to, that Becky is going to step in. She'll be the successor executor. So here are some rules. There are also rules in the will that provide, can Amy or Becky, depending on who serves as executor, are they entitled to commissions to be compensated for the work that they're going to do? Those are more rules. So
May I interrupt?
yes.
Okay. So even though you name someone as owner and I am the life estate person and I'm allowed to live there, I as the mother can live in the house as long as I'm alive. Now the person I'm the life estate, right? I'm the life estate. Say my son or my daughter is the owner according to the deed.
Well, they're not going to be so if you transfer property to your son and your daughter, but reserve a life estate for yourself, is that what you mean?
Well,
Or
the
you,
house is in his name and I can live in the house, his or her name, and I can live in the house as long as I'm alive. That's a life estate, right?
yes.
Okay. But does does provisions of a will override that?
Well, okay, so that's a very good question. So if there is an existing deed, I just want to make sure I'm understanding. If there is an existing deed that provides that John owns a house,
Mhm,
gives Pamela a life estate, the right to live in that house,
mhm.
that means that you and John, you really do have an ownership interest consisting of your life estate.
Right.
So in your will, the only thing that you can only give away in your will, something that you own, okay?
Right.
All you own with respect to that property is a life estate. And
Mm,
it evaporates when you die. It's a life estate. Once you
Okay.
die, it doesn't exist anymore. So there's nothing for you to dispose of in your will
Okay.
Okay.
As it relates to that house.
as it relates to that house. That's correct. That's John's house. And when you pass, he can do with it whatever he wants to do with it.
Okay, that's my question. Thank you.
You're very welcome. Okay, so somebody asked about a living trust. A living trust basically just means, it can mean a lot of different things. Generally, a living trust is a trust that you create while you're alive. It's established while the creator is alive. Whereas there are trusts that come into being through your will or some other mechanism on the death of somebody. But a living will can provide for a lot of different things. Usually in New York State, when we talk about a living will, we're referring to a revocable trust, that kind of trust I talked about earlier, where you create the trust, you put a house or something else into it, but you retain control over those assets until you become disabled or die. That in New York State, that's generally what a living trust is. And again, what I want to emphasize is that it has absolutely zero value in terms of Medicaid eligibility planning. It can be helpful to some people for other reasons, but it is not helpful for Medicaid eligibility planning at all. In order for a transfer to effectively remove assets from your ownership to, to bring you closer to Medicaid eligibility, you have to relinquish ownership and control over that property, which is part of what makes Medicaid eligibility planning difficult for some people, because they don't want to transfer their property to a trust or put their children in charge of it. It often makes sense to do it, but again, it's an individual question that people have to decide what they want to do. So the other thing I just want to repeat, because I said it at the beginning of the presentation, if you wish, feel free to put your name and your email address in the chat, and we can get back to you with additional related information or include you on our newsletter mailing list. If you are put on the mailing list and later decide you no longer want to receive the information, you just unsubscribe, and there's no problem with that. But if you're here tonight, you might be interested in some of the newsletters that we do put out. Okay, so I know we've been talking about a lot of sort of heavy topics. I don't want to keep talking if people are sort of losing juice or losing interest. So I'm going to offer to talk more tonight about Medicaid eligibility planning in addition to specifically saving the home, or to answer questions that have to do with how to protect the home. Is there an interest in me talking generally about more Medicaid eligibility issues? Okay, well, I'll go on for at least a few more minutes then.
Yeah, Annabel, I just want to make a suggestion. If this is a topic people are interested, maybe we can have a separate workshop.
That's a wonderful idea, because sometimes what I find, all of a sudden, I don't remember if this was supposed to be an hour or an hour and a half, but I find often that an hour is sort of the tolerance level for people.
Right.
So I don't want to talk if people are sort of tired. If you would like, so what I'll do is I'll wind down, okay?
Mm-hmm.
If you would like to have me come back and talk in more detail about anything that we touched upon tonight or any related topic, feel free to contact us or to contact Ilgar at the library directly, and she knows how to reach me, and I'm happy to come back and speak more in detail when you're more fresh, because I know that I reach a saturation level too on certain topics. In closing, what I just want to make everybody aware of is that there are very, very significant changes going into effect within the next few months in terms of Medicaid eligibility for home care. Up until fairly recently, there was no look back period at all for home care. If a person needed an aid, they could come to my office. We would figure out a way to transfer their assets out of their name, whether it was a second home or a primary home or a brokerage account or whatever it may be. We could transfer all of their excess assets out of their name and then apply the next month for home care and get it. There was no problem. And the assets didn't even have to go to a spouse or a caretaker child or a disabled, nothing like that, no restrictions. Now, however, there is a 2.5-year look back period going into effect within the next couple of months, which means that if somebody comes to me and wants to become eligible for community home care and they're over-resourced, we have to, there are still things that we can do, but it may not be possible to transfer all of that person's assets out of their name in order to make them eligible immediately for Medicaid to pay for a home care attendant. So really the takeaway when it comes to these changes with respect to community home care is if you're interested in trying to save your assets for your children or your spouse or other family members, speak to an elder law attorney as soon as you can so that you have greater options. The older you are, and the closer you may be to possibly needing the kind of care that Medicaid can pay for our senior citizens, the less likely it is that we'll be able to save most of the value of your assets. So pre-planning really does make a lot of sense in this area. So I just wanted to emphasize that. I'm looking if there were any last minute questions. And with that,
I do have a question.
yes,
Is a 401k considered is that considered excess assets?
thank you for asking that question. So we're going to go out on a very high note because this is a wonderful question and the answer is going to make you all very happy. And I'm going to wrap things up after this question, but Pamela, if you'd like to send me an email or call me one of these days, I'm happy to address another question, or even better yet, let Ilgar know you'd like me to, give a presentation on that topic. So Debbie's question, this is a very, very important question. Exempt assets include a qualified retirement account. If you have a 401k or a qualified traditional IRA, no matter how much it's worth, it is an exempt resource. So if you have $800,000 in a 401k or in a traditional IRA, I'm not talking about a Roth IRA, I'm talking about a traditional IRA, those assets are exempt. And as long as your other assets, in the ones that not including the 401k or the traditional IRA, as long as we bring those under $16,800, you can pass the resource test for Medicaid. That's a very important question, and I'm ashamed of myself that I didn't mention it sooner. So really, thank you for bringing that up. That's critical. There's a difference of opinion as to whether or not a Roth IRA qualifies. I don't see them as qualifying. I don't want people to count on that as being exempt, but a traditional IRA, a 401k, they are exempt resources for sure. Thank you for that. And I'd like to thank everybody for being here.
I'm sorry.
Yes?
That privately was a mistake. I was trying to write the message. And I don't know what happened, but it came up privately. Did you understand?
Something to me?
Am I still muted?
I didn't see it.
No, I erased it because I ended up asking the question. But when I was trying to send it, that's why we got that privately.
Perfect. Okay, I got it. I'm sorry. I'm trying to look at all of you and sort of glance at the chat. So I'm sorry if I misunderstood that. I'd like to really thank you very much for your attention, most of all for your really wonderful questions tonight. And here's our contact information if you'd like to reach us. I have other videos on my website. Thank you, Nelson Sanchez, for really being a terrific technology and marketing and manager and friend. And Ilgar, did you have anything you